So hello guys, so we are going to jump directly into the first chapter of CS Executive, sources of law from jurisprudence, interpretation and general laws. So firstly we have natural school. So these are the schools of law, various schools of law. We have 5 schools of law, and these schools of law, they give better understanding of what law is. So the first one is natural school of law. So I have written only realist here. So we have, firstly we have natural school of law. So what is natural school of law? So the natural school of law is also known as law of God, moral law, divine law, law of reason, law of nature, unwritten law. So that is very important. So natural law says that certain rights are inherent by virtue of human nature and can be understood universally through human reason. So here are some jurists who says the definitions of the natural school of law. We have firstly we have Alpine here. He defined law as the art or science or what is equitable and good. The art or science of what equitable and good. Cicero said that law is the highest reason implanted in nature. So what is the highest reason? Whatever is reasonable to us should be the law. Justian's Digest defines law as the standard of what is just and unjust. So very important jurist who is that? Salmond. Salmond is a very important jurist here. Salmond says that the body of principles recognized and applied by the state meaning the government, in the administration of justice. The justice is also known as it is acted upon the courts of justice by the judge. And the second school of law is positive school of law. A famous jurist defined it, who is known as John Austin. It is also known as command theory of law. So John Austin believes that laws take away right from the people. So he also says that if a person does not imposes a duty and is backed by a sanction. So what is sanction? When the law is not followed, the person is punished. So sanction means punished. So in his rule, he has 3 elements. First one is politically superior or sovereign. Sovereign is India. So these rules will be implied in our country. Second one is command of sovereign. Third one is sanction. So first one is sovereign, second command, third is sanction. So anyone other than the politically superior makes the law, it is not considered as law. Anyone other than the politically superior makes the law, it is not considered as a law. Okay. Also with the positive school of law, here is another jurist who is known as Kelsen. So Kelsen defines it as, he gave the pure theory of law. He also says that law is a normative science which prescribes certain rules. So he also called law is the ultimate norm called Grund norm. So what is Grund norm? For India, the Grund norm is Constitution of India. It is the supreme power. Grund norm meaning the supreme power. So what is the supreme power of India? It is the Constitution of India. Second one is historical definition of law. Third one. So there are 2 jurists. First one is Savigny. Savigny says that law is a matter of unconscious and organic growth. Law is not universal in its nature. Custom not only precedes legislation, but it is superior to it. Law should always conform to the popular consensus. So customs is derived from law. legislation is the last stage of lawmaking. So legislation is the last stage of lawmaking. And fourth one is sociological definition of law. So in sociological definition of law, we have three jurists. First one is Duguid, and whatever. So we have Duguid defines law as essentially and exclusively a social fact. Herring says that the form of the guarantee of the conditions of life of the society. He also says that the law is coercive in character. And we have our important jurist here, who is Roscoe Pound. So he says that he pulls off political philosophy, economic interests and ethical values constantly struggle from recognition against background of history, tradition and legal technique. So Roscoe Pound thinks of law as, he says that law as social institution to satisfy social wants. So this line is very important, which is social institution to satisfy social wants. So this line means the claims and demands and expectations involved in the existence of civilized society. The claims and demands and expectations involved in the existence of the civilized society. So the last school of law is realist definition of law. So the realist definition of law is that it was stated by Holmes. He is also a jurist. So he says that law is a statement of the circumstances in which. So here we have, law is a statement of circumstances in which public force will be brought upon through courts. Law is a statement of circumstances in which public courts will be brought to bear upon through courts. So in here, law is nothing but a mechanism of regulating human conduct. So law is nothing but a mechanism of regulating the human conduct in society so that the harmonious cooperation of its members increases. The state meaning the government, in order to maintain peace and order in society, formulates certain rules of conduct to be followed by people. These rules of conduct